rumors spreading round in that Texas town about the shack outside the
Okay,
game.
if we can find our seats, everyone, I'll try to keep this train on time. Our next group is our Legal Eagles. We have Mark Richards, Bill Anthony, John Gorsline, and David Mattingly. Gentlemen, we're going to handle this just like we have with all of our panels. We'll start at the end. You can introduce yourself and who you're with.
My name is Dave Mattingly. I'm an attorney with Ice Miller here in Indianapolis, Chicago, and Columbus. I've been in motorsports my entire legal career, represent the Indianapolis Motor Speedway, Indy Racing League, and a number of other racing interests. I do basically risk management and litigation, so I get the benefit of advising clients, and then when things go wrong, getting to defend them in the courtroom. So.
Nice introduction, Dave. I'm John Gorsline of the Gorsline Company. 46 years in the racing business. I love it with a passion. We insure race car drivers mainly. We'll do cars occasionally. And we go to 50 races a year all over the world to be able to be with our clients. And we'll talk about claims when we have time. Thanks.
Good morning. My name is Mark Richards. I am a partner with Ice Miller here in Indianapolis, a partner of Dave's. I've been a lawyer for almost 30 years, practicing in the motorsports area as well, working with the Indianapolis Motor Speedway, the IndyCar Series, and some race teams and drivers during that time. Dave and I are kind of a tag team. I work more on the business side with Dave more on the litigation side, and happy to be here today and answer any questions you might have.
Howdy, y'all. That's my Charlotte, but I'll do my California from now on. I'm Bill Anthony. I work at Motorsports Management International. We're a driver management firm, motorsports consulting firm out of Charlotte and Los Angeles. I'm also an attorney and work with Mr. Agajanian and have been doing that for many years, and am a former heroic go-kart driver. So.
All right, that's what we like to hear. Okay, guys, while I might present the question to one of our panel, please, if you have something to add after their answer, feel free to jump in, because we do have sort of a great all-star lineup up here. I am going to start out. How are the legal needs of the racing industry different than other sports and other businesses?
Well, I'll start that. I guess the first is simply the fact that racing is a dangerous activity, and so there's a lot of precautions that are taken. I'm not sure that the precautions themselves are a lot different than there are in other areas, but if we get into the discussions of releases, that sort of thing, the discussions of insurance, literally without proper release programs, without the proper safety programs, without the proper insurance programs, you can't survive in the business. And then beyond that, you're dealing with a number of organizations that depend on unification, and then they have as their representatives independent contractors who are not subject to a collective bargaining agreement. And so all in all, it's kind of a unique situation, which means that you've got all of the problems regular businesses have with all of the additional attributes of a unique industry.
Yeah, just to elaborate on Dave's point, you have a lack of structure within racing that you have in other sports. With the collective bargaining agreement, it provides a lot of simplification in terms of kind of a unified front with teams that have players and personnel employed by the teams and a unified negotiating front, whereas you have a much more non-unified negotiating front with teams kind of representing themselves. You have drivers representing themselves. Then you layer on top of that the fact that you're doing business in multiple jurisdictions and the complications you get with needing to comply with the laws of multiple states and in some cases multiple countries. And you've got to take that into account as well.
Adding to the fact that it's kind of scattered, it's just a volume of complication. You have teams, sanctioning bodies, racetracks, drivers, sponsors, guests, vendors, contractors, and they're all somewhat pulling in the same direction, but they all have their independent interests. There's a lot of liaison work, a lot of communication work that I think makes it much more complicated than other areas. And there's agencies. Everyone's got an agency. Everyone's got an attorney. Everyone's got a representative. So it's just complicated and scattered, like Mark said.
Well, none of my insurance needs are matching up with some of the big deals that you do, John. My insurance agent told me, think backwards when it comes to insurance. Think about the claim procedure and work back to deciding how much coverage you need. Can you talk a little bit about the claims procedure and also, just the simple nuts and bolts on filing a claim?
Well, the claim is probably the most important part of insurance, which no agent or broker ever talks about. We probably pay more claims than anybody else with individual drivers. And it is important for the driver to realize what medical policies are available for the sanctioning body and the track and himself that he can buy, what disability policies he can buy to cover his income if he can't drive, to cover his career-ending injury if he can no longer drive, which Dario will be using shortly, which many people will be using and seeing in the racing world. There are a lot of claims. And the broker that can handle the claims has the experience working with the attorneys, working with the accountants, and I think that's key.
How has that changed over the years with your experience?
I defer to the attorneys to answer that because it's been so difficult with the law changes, don't you say, Dave?
Yeah, I think the basic fact is you can't have too much insurance if money was not an issue in terms of paying the premiums, and it's so important to have the right insurance. From a practice pointer standpoint, from the standpoint of things you can use, I'm amazed how much time people spend trying to allocate risk based upon some sort of fault. And people shouldn't be doing that. They should be allocating risk in a way that defines who's going to buy the insurance to protect against that risk. And that solves a lot of problems. And it also results in people not duplicating coverages to any extent to make the overall experience of a particular project more reasonable. I can elaborate on that at some length.
Well, I have tons of questions for these folks, but it's very rare that you get this many brilliant minds in the legal industry together on one stage and you're not paying them by the quarter hour. So if you have any questions out here.
Actually, every 20 minutes.
Are there any questions? And again, please introduce yourself.
David.
Okay.
David Barton, Thunder Hill Raceway, Willows, California. Mr. Barnard, I believe, came up with the idea of uniform regulations, specifications, and criteria for track designs. Very adamant in his recommendation that we all comply with a fixed set of construction and application and operational rules. I think the other side of that was that we would then be held accountable for not complying with them all. Do you have an opinion on track safety relative to uniform rules and standards and so on from design and execution and operation?
Well, based on some of the litigation that I was involved in California, that's exactly right, the concern, which is if you're prepared for the oversight, maintenance, and management of that, that's going to be the key component. Like you're saying, once standards are established, you know that claims are going to be guided by those standards to the extent they're accessible and published. So we've run into situations where it's great to have a design or a layout, and oh, by the way, how come that barrier is here instead of here? Because the drawing says it's here. Oh, I have no idea. So you need, if you're going to have standards, you're going to need to make sure you have a proper and appropriate implementation standard that's consistent, and you're going to have to realize that you are creating your own claim standard.
Yeah, I mean, I think whether you want that or not, there are going to be minimum design standards that are going to control the construction of a racetrack, and you want to know what those are, and you want to be able to comply with those. But I say minimum because every track's going to be very unique. The style of racing on that track is going to govern a lot of differences in design, and ultimately you're going to be held accountable for your decisions in that regard. There's actually a comfort that comes with some uniform designs. The FIA provides those by licensing, of course, and grading the racetracks for a type of racing. And you know, this is a good starting point for track designers and track owners and promoters.
That's really the challenge, right, is that there is a varied, right, there's different types of surfaces, there's different types of cars, different sizes of tracks, different locations, different types of events. And the problem is that it gets very complicated, is that the court and the plaintiff's attorneys aren't going to understand the distinctions and variations as well as your client, your track, your attorneys, and it's a very difficult prospect to relay that information and establish that, because there isn't going to be one uniform document that can apply to everybody across the country in all circumstances, and that really is the problem.
This is really an area where no good deed goes unpunished. I mean, when you make a real effort to try to identify all the things that you can do to improve a track, both from participant and from fan safety, the problem is if for whatever reason, time, economics, other considerations don't allow you to do that, then you're judged as to knowing about it and not doing it. And then when you make an effort to try to identify them, I can tell you that after any kind of racing incident, any kind of track incident, everything looks foreseeable. I mean, after the fact, it looks like the most obvious thing that could have happened, and so easily preventable if you'd just done 1, 2, and 3. And so when you don't even identify it as a problem, it looks like the people who are doing that identification process, your designers, your maintenance people, are asleep at the switch, and so you have to deal with that.
Never underestimate the Monday morning quarterbacking by the plaintiff's attorneys and their experts. I mean, that's just the reality. And you're going to have, in designing the track, you're going to have, you know, cost considerations. You're going to have the desire to maximize, you know, the spectator views and practical considerations that come into play. But at the end of the day, you've got to treat as a priority, you know, the safety of spectators, the safety of the participants on the track design.
Someone mentioned this on the very last session I was listening to. If participant safety was the only issue, you'd have 10-foot solid walls around the entire racetrack.
I'm waiting for the first lawsuit from companies that they don't have a safer barrier.
Well, you know, it's interesting. At one point in time, I represented 2 different small tracks, and one of the tracks had fencing, and the other track didn't. And simultaneously, there was a lawsuit that said it was negligent for a track of these type to have a fence, and the other one would say it was negligent not to have a fence. And you know, and the experts were equally convicted convinced that their position was correct.
Hi, Tom Blair, Bowling Green, Kentucky, the National Corvette Museum. We're building a club-level track road course, and I'd like your opinion on the downside of using legal counsel locally in a non-motorsports community as opposed to seeking out legal services from a motorsports firm.
I'll start by saying that the local lawyers usually know the local needs of your business, and there are good there are good local lawyers every place, and I'm confident that Bowling Green's is no exception. I think when you get into certain kinds of areas, you ought to use the expertise that's unique to that industry, and you can get that from both your insurers, the industry, and from motorsports lawyers. And my recommendation is that you use your money wisely and do locally what can be done locally, and then go outside to kind of put the fringe things that need to be looked at. For example, I regularly do what I would call a risk management assessment. And I look at the releases, I look at the various activities and make suggestions as to how they can do that better. That's much cheaper than trying to be on the design stage from the beginning, often. So,
I'm not against using local counsel. I think it's good for purposes of understanding the community and understanding the facility. I think at one point or another, you're going to have that counsel connect. In most circumstances, you're going to have them connect with somebody with motorsports experience, whether it's to find the proper expert witness or to learn lessons from other facilities that have suffered similar incidents. So I think it's a combination of both, really. But, you know, for your convenience, you need to have someone local that's willing to work with others, I think.
Yeah, many of these things are really kind of procedural, too. I mean, it's simple things, and I try to bring in practice pointers. But, for example, Kentucky and in every state, if you're an adult, you're considered have a legal right to contract, and that includes waiving away your liabilities and assuming risk, but you have to know what you're doing. And often tracks use multiple signature forms for their releases, and it can be simple things of making sure that one of two or both things occur on these multiple releases. One, that they're not folded over so that the language doesn't appear and people think it's only a sign-in sheet. And then to that extent, you have language at the bottom which says over where they have to sign, this is a release, please read. All of these things are designed to make sure that your waivers are enforceable. To address your point, that isn't even an issue of the waiver. That's a procedure, but it's a procedure that's violated often and not even picked up by local councils who don't deal with the problems that occur in racing. They don't even realize it occurs until after they've had a lawsuit, and then it's too late to do anything, as an example.
To revert back to Dave's question, Dave Auden's question, Mitch Wright, National Corvette Museum, Motorsports Park in Bowling Green. You had mentioned, Dave was asking about design standards and all, and you had mentioned obviously you can get an FIA track certification, and then to a lesser extent SCCA will come in and do a track inspection to verify the track meets their requirements for club racing. Does that offer us a additional layer of well, you've built the property to industry standards, so does that give a level of protection, or
It is a starting point. It's not a safe haven. The question is if we do all these things that these organizations that are professional ask us to do, are we now in a protected category and can't be sued? And if we are sued, will we win? And the answer is no. It just means that there's a greater chance and likelihood that you'll be able to, well, first of all, it's a greater likelihood that someone will bring the suit to begin with. It's a greater likelihood if the suit's brought that you'll be able to settle it, and it's a greater likelihood that if you have to try it, you'll win it.
As Mark said earlier, you know, the money quarterbacking, if you're looking at it in reverse, they're going to say, well, what should they have done? The better that you can answer that question, the more things that you did or the more things that you looked at and considered, the better off you would be.
The super tracks have a dilemma in that the expectations are so high. So for example, at the Indianapolis Motor Speedway, it isn't the question of whether the wall and the fence meet some sort of industry standards. There's an expectation that they're going to be the best in the industry. And so you approach it that way, and you approach it that way with the expectation that when those questions are asked, you've got good answers, and your management and the people who are responsible for answering those questions can do so with a lot of confidence. And that requires pre-planning and as somebody mentioned here on insurance, thinking backwards. Is the fence high enough? Does the overhand good? Is there enough support? Is the mesh strong enough and the cabling system strong enough to do what jobs it's supposed to do? And if your answers to all those are yes in a reasonable fashion and exceed some expectation of what's going to occur, I think you're in pretty good shape.
John, from an insurance standpoint, how does someone decide how much insurance they need? That seems like a very simple question, but usually the answer is a little more complicated.
There's no exact formula. It's the advice of the attorneys and the managers that think what the client needs. And as Dave has pointed out, that and you said thinking backwards is key to figuring out the right amount. Wouldn't you say, Bill?
I thought it was whatever was cheapest, but
we know that.
Because you got to save the money for the attorneys. Sorry.
And Dave, no matter how much a facility prepares ahead of time, there's going to be an accident. There's going to be a problem. Somebody's going to get hurt. There's going to be a tragedy. What's the best advice? I once did some play-by-play work for a racing series, and the promoter told me, if anybody comes up to you after we have an accident, don't say we're sorry, because even though you don't work for me, your comment of saying, oh my goodness, I'm sorry this happened, puts you in a bad state perhaps. At least that was his perception. Yeah. What's the best advice for after an accident?
Well, this is a seminar of its own, but obviously most of your ability to make proper responses after an incident is your preparations before the incident. So you need to have, as I was saying before, all the things in place that makes you feel comfortable that you did the things that were appropriate to minimize the risks that you know is likely to occur, even though you don't know how it's going to occur. Second of all, once it occurs, I think you need to have very human responses to things. I mean, whether it's your fault or not, if a race driver is killed on your track, that race driver is part of your family. I mean, you feel sick, you're sad. You feel sorry that this happened just like everybody else feels sorry that it happened. If the unlikely event that something gets into spectators, if you've done everything one can do, the reality is no one can expect to sit behind a barrier that you can see through and watch racing at 175 to 225 miles an hour and not have any risk whatsoever. The real question is, can you say with some certainty, we did the things we want, and then I don't know that it's wrong to be sorry that it occurred. I just don't think that you're assuming fault for having occurred. There is a calculated thought into what you say afterwards. The Indianapolis 500 had an F1 event in which 16 of the 20 competitors pulled off the track for the first lap, so that the race was among the remaining 14, and so that the remaining race was six teams. And the fans were quite unhappy. And, from the Speedway standpoint, we prepared a wonderful stage. It was a beautiful day. Everything was in order. It couldn't have been a better day. And the participants, for various reasons, decided not to compete. Our response to that was, we're disappointed too. Our management basically got up and said, how do you feel about this race? We're disappointed too. Did you feel like this was the kind of event you wanted at your track? We're disappointed too. But that's the truth. And those are the kind of things you need to think out and leave the questioning to other people.
What I would add to what Dave just said, and I would reiterate what he said about the best thing to do, the best way to respond to an accident is in your preparation beforehand, absolutely, because first of all, your preparation should include and undoubtedly includes safety plans. I mean, every racetrack has a safety plan. The sanctioning bodies have safety plans. your sanctioning agreements, the contract between the sanctioning body and the racetracks, allocates responsibilities so that if some sort of a problem occurs, there is an allocation of duties and responsibilities as to who does what to, in terms of, the safety accident crews, the medical rescue, et cetera, so that you don't have a Keystone Cop routine going on trying to figure out, okay, who's responsible for handling this. You don't have gaps, you don't have duplication, you have a clear, efficient way of dealing with the needs of the situation because you've prepared for it in advance. And in that respect, you have communication beforehand and you have communication afterwards. And what you have to do when an accident happens, is particularly when it's a tragic accident, like Dave mentioned, is you have to have communication, and that communication is, you have a race going on, you have ops people. There has to be communication with your public relations people. There has to be communication between the sanctioning body running the race with the racetrack people. There has to be communication with your television partner. There has to be communication with, all of these key constituent groups dealing with this. Okay, we're live on air. What are we doing? Are we red flagging the race? Are we going to continue the race? What's going on? Communication is critical in dealing with these situations, and there has to be a consistent message. You can't have one group saying one thing and another group saying something else. And now keep in mind, in today's world with social media, and people can be sending texts and God knows what else, that's not as easy as it used to be in terms of controlling the messaging that's going on. And so, you've got to have that under control as well. And people, if there's an accident, keep in mind everybody in the stand, has a phone which can take not only pictures but video, which can suddenly become evidence if there's a lawsuit afterwards as well. And so you've got to be sensitive to preserving evidence, chain of custody. Again, if there's a fatality, you got to be sensitive to the coroner's office and the obligations you have in that respect, and you've got to, be aware of all these needs you've got to deal with.
Speaking of social media, now, it used to be very easy to control the story and to make sure that it all funneled out in one direction and everybody was speaking on the same page or singing from the same hymnal. When it comes to social media now, and the best time to think about these things is way before the accident. From a legal standpoint, what sort of training, what sort of advice would you have for folks as to what their policy should be with social media and all their track workers and their people? They're working officially with the track. Obviously, can't contain the story from the fans or the media. But what would be the best advice for the facilities thinking before the lawsuit on social media rules or ideas on how to control the story when there is an accident?
Well, I think this is easier said than done. You have a public relations department for a reason. Your messaging ought to come from them. And so, you ought to have a policy that prohibits messaging from anybody else, and that includes through social media. And
having a policy, even if it's not always listened to and followed by people, is that a better strategy than letting it be a free-for-all? Are they more protected if they have a policy no matter what ends up happening?
Well, I think you have a policy whether you have a policy. If you don't have a policy, then you've got kind of a free-for-all. This goes the whole thing. You need to anticipate the kind of problems you're going to have. One of the problems you have now is that nothing goes undetected. Everything is being filmed. Everything is being tweeted and text and emailed. Everything that your people say will either be discovered immediately or will be discoverable later. So if you've got some employee who sends out a text that says, "This is the worst F-up I've ever seen at a track," you're going to have to explain that. So what you'd really try to do is to basically make it clear that you don't make those kind of statements. they wouldn't even believe the statement 5 minutes later, but you got to stop that from the beginning, and you have to anticipate that all emails in litigation are going to be discoverable, and there's going to be long tracks, and the fact that they may be erased doesn't mean that they aren't recoverable. And the best way to do that is have a policy of what's said and what's not said and who says it.
Two words that I pulled out first, what Dave said, anticipation, and then what you started out with saying is thinking, right? You got to think about all the scenarios. There's a ton of scenarios and situations, and you have to think about the reactions to those too. Like the situation that comes to mind is the Kyle Larson accident at Daytona. There was a handheld video in the stands of the tire. It got immediately posted to YouTube. Then there was an issue with it where it appeared to have been pulled down. Immediate firestorm. The evil empire must have snuffed this guy out and stolen his camera. They're trying to control the story. How can they do that? Power to the people. Oh wait, never mind. It's back up again. Forget about it. So you just have to realize and understand not only the initial layer of having a policy and understanding what you're going to do and what your policy is, but the ramifications and where it goes from there, and how you're going to respond if there is a lashback from that.
Yeah, I mean, I've had so many clients say, boy, this is so unfair, this isn't even true. This isn't right, and of course the answer is perception is the reality. And if you don't try to control as much as you can the perceptions, and those perceptions you control be in light of what really is truthful and accurate and correct, you're going to be in trouble.
Any more questions from people? While I'm coming back there, one of the things I wanted to ask is about liability waivers. What's the best advice?
Real fast is I just already said, liability waivers are recognized as enforceable in every state. You get into some issues when you get into minors. I'm happy to explain that if that becomes somebody's concern. States like Wisconsin don't even recognize sometimes parents' signatures on behalf of minors. That's certainly true in Florida also. But there also are waivers and there are waivers, and waivers are intended to be as much as possible a single-purpose document, and it needs to state very clearly in every state that one of the things that the person is incurring the risk of and giving up the right to claim liability is for the person that releases negligence. If you don't say that in almost any state, it's not a good waiver, and it's amazing, and this gets into the indemnity area also. I'm just amazed how many waivers aren't worth the paper they're written on, and if you go to some good waivers, you'll see immediately what makes them good and what makes them bad, and I can go on forever on that.
There's something from a practical perspective that I've seen in a couple instances this past year, and actually Dave was bringing it up in our pre-discussion over there. The simple things, right? We all know what the form essentially looks like, and we all know what the industry has largely accepted. There's blanks to be filled in. It's not very complicated, but a significant portion of the time when a claim arises, you're going to have a form that's missing a date, that's missing the name of the track, that's missing the name of the witness. I mean, simple things, and those things make a difference. And the practical situation that I've seen the last couple of years is people that were regular attendees at a track that signed a waiver every single week except for the day of the incident. Okay? So they have, well, I got these 20, but they're all prior dated. Can I use these 20 for this day? Depends on what those 20 say. If those 20 are limited to that day, you can make, hey, I'm all there, I'll be behind you making that argument, but you might have a tough road to hoe there. So something to consider, and it's not an issue on the NASCAR level because they already implement this, is license or membership annual applications that include a release that cover all activity in the year at that facility, so that if there is a missed release on a particular day, you have a secondary document to fall upon. Smaller tracks don't always have that. Most sanctioned events do, but some of them with smaller sanctioning bodies or smaller tracks do not. There's no harm in perhaps coming up with a system as a fallback for something like that when a date is missed or a blank is not filled out.
The bottom line is you need to have good waivers, and then you need to have a procedure in which they're properly executed, and then you have to have a retrieval system. I'm amazed how many times, especially small tracks, they've done everything right, but they can't find the releases. Now, electronics is starting to change that a little bit and make it easier, but it brings its own issues, and again, that's a topic for another long seminar.
I think you answered my primary question about signed waivers, but what about the language on a ticket that's releasing liability? Could you discuss the effectiveness and enforcement of that?
It is a very, very good argument for a defense lawyer, and it is proof that the person understood and incurred the risk and that there was a delegation, and usually those tickets say that the ticket holder's use of the ticket is her agreement to incur the risk and to release. Because they haven't signed it, and often you tie those ticket purchases in with some sort of signing and release. But just the ticket language in the back gives you an argument to make before a judge and a jury. It does not give you a right for a summary judgment, which means that ultimately you're going to be at the risk of what a judge and more likely a jury is going to think about that. It's almost important to have disclaimers on the back of tickets, because my experience is jurors so expect that if it isn't there, it's just the opposite. Is that no one's incurring any risk at all. So it's important, but it is not one of these magic bullets that's going to protect you from litigation.
One question I have for the panel, and I'm not sure who wants to grab this one. I've been to some short tracks and unsanctioned tracks where it looks like the liability waiver I'm signing was written during the Eisenhower administration. How often should a track review that and have a new liability waiver in place? How often does the law change?
I'm going to make this my last answer because unfortunately I have to leave, and so don't think that my leaving now has any reflection of how much I appreciate you being here. But the answer is that as part of your annual review of your procedures, one of those should be the releases. Now, fortunately, insurance companies have gotten very good at having good standardized releases and require you to use them as part of their providing coverage. So some of your obligations and needs are forced upon you by your insurer, and that's good. But if they're not, it's something that should be reviewed annually, and not just the release, but how you get execution of those and how you retrieve them when they're necessary to be used. And keep in mind, with minors, you're talking about someone who could be injured at age 2 and not have an obligation to bring a claim for another 16 years or 18 years. So there you have it. Thank you. I'm leaving you in good hands.
Adding to that a little bit, you need to have a conversation regularly with your friend, your insurer. He's on your side, and you need to make sure you're doing what the insurer is requiring to do, that changes are passed by and approved by them. You need to work in conjunction with them and make sure you're all on the same page. That's an extremely important thing, both from a policy coverage perspective and just from a common sense perspective.
I have a question. There's a significant amount of expertise up there on the stage, both legal and insurance, and if you're a top-level driver, you have access to a lot of managers and to the resources that are there. But as we all know, there's a significant population of young drivers out there across the country, all around the world, and it's mom and dad that are basically running their careers. And I've worked with a lot of young drivers, and they have no idea where to get legal advice that has expertise in motorsports, and nowhere to get, and don't even know they need to get insurance, maybe beyond what they've signed or that they think their sanctioning body is. So I don't know if it's a question or more of a highlighting of that. I think we really need to somehow get that down to the lower levels, and I know that, you know, that expertise there and that is at the top level, you guys take these clients on because they're not, you know, they don't have that kind of affordability. But somehow I wish the information could get disseminated down and maybe be more available. Have a crisis plan, you know, somehow. And I don't know if you can address it, but it'd be great if any of you could. What? families could do.
Well, one of the topics that was originally circulated by us to talk about was how this industry, or how drivers are different from participants in other sports. There's a lot more responsibility on the driver administratively, and to prepare themselves and to think long term, right? Drivers at the smaller levels, I mean, you know, Mr. Agajanian has been around short tracks for 50, 60 years. We've seen and know all these people. We know it is a challenge for a lot of them. Are you calling Kerry old? I think he'd call himself old, would you not? Anyway, most of them don't have corporate entities. They don't have liability insurance. They don't have disability insurance. Maybe they have medical insurance, maybe through their parents, maybe separately. These are all things that are difficult to think of on, you know, on a grand scale when what you're worried about is eating and tires and getting to the track. And we realize that. And we've worked in our driver development a lot with companies like John and people like John to try to develop programs, say on the disability level, that give them access to a market that was generally only for the larger clients, you know, Tony Stewart and Casey Kane. A lot of the problem, and John can speak to this a little bit more in terms of the, you know, what's available to them, but we've tried to put together, whether it's kind of packaging guys together to give them, you know, access to coverage at a reasonable price. That's obviously a big part of it for these drivers, is they don't have that kind of money to pay huge premiums on disability insurance. But these are important things, and you're right. There is someone that needs to be there to talk to them, to say these are the things you need to think about: your family, your obligations, your children, you know, and how you're going to handle yourself in a crisis. And we do what, you know, a lot, or we try to do a lot, but there's so many people across the country. Our ears are always up, and we're always available for people to call us and talk to us. I don't know if we can represent everybody across the country, but we certainly have conversations with hundreds of people every year, and that's the type of stuff we agree with you that that's more what people need to be thinking about. And, you know, and I know John's worked very hard in trying to pass these benefits and policies down to other people on the lower levels as well.
And John, how can you tell that your insurance guy is a good person at setting up good protection for you and not just an excellent salesman? What do you see in a good insurance broker that tells you, okay, this is a guy who's representing his clients well?
Well, that's a very difficult question, Dennis. Kerry has done a great job, and Bill has done a great job, and many of the attorneys and advisors to the young drivers have really helped tremendously. I think the only way you can tell a good broker or agent is by their track record. And if they're new, they need to get with an older guy that can bring them along. Andy over there has developed a whole package for young drivers, a spreadsheet of everything that they should need to consider. And the agents that we work with, the attorneys we work with, absolutely love it, because there it is, step by step, everything the young driver could possibly need.
And in many instances, it's one of those things where, answering your question, how do you know you're with somebody good? You know it when you know it, right? And unfortunately, a lot of times that's when you don't want to have to know it, okay? And I can tell you that, you know, the experiences we've had, say, with Andy and John, I mean, we just dealt with Jason Leffler this past year. He was a client of our agency, and that was a very difficult time and a difficult thing to go through. And it's when people like John and Andy stepped up to be there and support administratively, that's when you know that's what the system's supposed to do and how it's supposed to work. So, you know, you don't want to have to go through that, but there are a core group of people that are known in the industry, and I think it is important to get with someone who's been around a while and knows the proper people to get in touch with.
Any more questions? Okay, I'm going to come to you, but first I'm going to kick it back to Tim.
One of the things, I mean, we've all been to a lot of these sessions that are going on. A couple of housekeeping things. There is a group that is co-founded by Mark Richards, which is called TRAC, the Racing Attorneys Conference. The website is actually called racingattorneys.com. And it's held every year in April. It is alternating between Charlotte and Indianapolis. And Mark, you tell me if I'm speaking online. No. Quote unquote non-lawyers are welcome.
Absolutely.
Obviously, more people that go through. I have learned more at that conference in the last several years. I think we've had 6 years now, I think.
That sounds right.
It's a really unique event because it goes and gets kind of the open field community, legal experts, with the Charlotte guys, kind of north versus south, Mason versus, representation. So I recommend you following that and learning because it is this whole session here between legal and then insurance, and there's a lot of insurance people are in here. We could go on for days on that type of stuff. So I just want to recommend that as a great resource to consider for your planning in the spring. So that's
Final question, right down here.
Thank you.
There we go. Is there any case law that's pending, anything that's gone through the courts or is going through the courts that'll affect how we do business?
Yes. I'm sure there is, and I'd have to sit here and think about it for a second, but there are always variations. One interesting thing, following up on the insurance comment, I'm aware of a claim at a motorsports recreational facility and where there was a payout, and now the insurer is considering or looking into perhaps making a claim against the broker for a failure to disclose a full list of events that was going to take place at the facility. And I think that whether or not that would be successful or not, that's something for food for thought in terms of, again, conversation with your insurer. They should know everything that's happening at the facility, all the events, the type of activities, so that they can tell you and assure you that you have what you need in place. So that's one thing that I see, but there's always waiver cases and variations on that as well.
You know, one thing I might mention, this isn't a pending case, but there's been some talk about the use of independent contractors within racing, and that's very common. You need to understand that just because you sign a piece of paper saying I'm an independent contractor doesn't necessarily carry the day. I mean, there's just an unlimited number of cases where the Internal Revenue Service and states have challenged somebody's status as an independent contractor, regardless of the fact that you've signed a contract saying I'm an independent contractor. The IRS has traditionally had a 20-factor test. The Internal Revenue Manual has a 50-page dissertation on the subject where they've kind of focused on, 4 or 5 of those 20 factors. And with Obamacare, whether you've properly classified somebody as an independent contractor is taking on increasing importance. This has been high-level, talked about as a high-level initiative over the last couple of years with the Department of Labor. It's not only a tax issue on whether you ought to be withholding and remitting payroll taxes and you're not, but it can affect pension plans. It can affect labor issues in terms of wage and hour requirements. It can get very nasty if somebody comes in and says, well, even though you're treating that person as a driver or some other worker, on your crew as an independent contractor, we don't think they are. Keep in mind with racing, you're doing business, if it's NASCAR, 30-some states, each one of those states could potentially come in and challenge the characterization of a worker as an independent contractor. It's not just the federal government. And the stakes have just ratcheted up with Obamacare. So that's something to be, sensitive to, that, again, just because you sign a document saying, I'm an independent contractor, doesn't necessarily make it so.
And that's, for smaller tracks and facilities with limited resources, that's often an issue relative to track officials, track workers, cornermen, volunteers. And that's something you should always consider. There's a recent case that just came out, and I'm trying to remember the jurisdiction. I think it was North Dakota or South Dakota. It wasn't a racing case, but it was an event, like a recreational event with a volunteer who was injured, made a claim for and received workers' compensation, even though the entity was not claiming him as an employee, and then turned around and sued the entity as an independent contractor, and that litigation was continuing to go on. The facility tried to do a motion to dismiss it, saying, hey, he's already made his election, saying he's an employee and he's already received benefits, you should dismiss this claim, but the court didn't do it at that level and was letting it proceed, which does not make sense, but is a reality, and I've experienced that also with the entertainment industry with people that are contracted to work on productions. You cannot predict what's going to happen in a court, an independent contractor-employee situation, but I can tell you that the entity is not the one that's going to be protected more than the individual. It's going to be whatever's to the benefit of the injured person is more likely where the direction it will go.
Just quickly, can I shout it?
Sure.
Yeah, there's always waivers between the event sponsor and the driver, and the track and the driver. Have you ever run into a situation of driver to driver or driver to instructor claims? Because there aren't waivers for those, typically.
Yeah, there are some cases driver to driver, and those, but the one, I mean, there is an instance in California where we dealt with an instructor that was a co-defendant of the racetrack against a driver, and that came down to more the adequacy or inadequacy of the vendor agreement between the racetrack and that instructor, because he was an independent contractor, and whether he was obligated to indemnify the track for his conduct or not. That waiver that is signed at the track covers so many classes of persons that it would probably cover and include instructors and the employees and other affiliates and agents at the racetrack. So the issue is more the contract between the instructor and the facility, which we're finding are always, that's something else that gets largely ignored, and that's something that should be reviewed regularly, and you should get your insurance certificates and make sure that the language in those vendor agreements is actually protecting you.
Great question. Well, our legal and insurance experts, thank you very much.
About to check outside the game. And you know what I'm talking about. Just let me know if you wanna go to that whole mile on the range. They got a lot of nice girls.